Dumelang, welcome. Hey, Svo. Tabang, I see you retain leadership. Guys, I just came back from running. Dumelang, hi everyone. So 13 people are here so far. How's everyone doing? Good evening. Hello. Timby, hello. I see you. Pat, how you doing? Tlohi Dumela. Hey, Loli. How's it? Hi, everyone. Let's see. Right on. Clement is here. Hey, Tseho. Rar.
Hey, Rafole.
How are you, Rar?
Kimonato outside. Go in now.
I ke tswa go siana ntate ke kgathetse mari re fire no.
Oh no, le ka tsamabile.
A ra ke re gone re zama bophelo ka mo le ka mo.
Are boleke mosimane wa itshomo.
Thanks, Raga. Thanks for making time. And apologies to everyone. It's just 5 minutes after 6. I don't think we're too late. We have an hour for the session, and I think we're going to do justice to it. Perhaps let's just give it 2 minutes, Clems. There's 40 people now online. I have 42 or so. We can just maybe do a live session and start. But I think true to form, firstly, last week, would like to just apologize profusely. ESCOM had other plans. I think we were meant to finish off the final questions on parental rights and responsibilities. And after completing that session, I was load-shed. So it was not a reflection on our guest or anything, but other than ESCOM really doing what he does best. And apologies for that. So today's session really is going to focus on divorce law. We will be looking at various topics related to divorce, such as spousal maintenance, issues such as forfeiture of benefits, cohabitation, aka fat and set, and possible consequences associated with that, and issues that will arise as part of your questions and answers. Like what we did last week, I think we would give Clement the first 20 to 30 minutes where he can just speak concepts and just take us in. And then we use the last 30 minutes for a Q&A as well. I've received some questions. I've noted those. I will be putting them to Clement at the right time. But if everyone is happy, Clement can just basically do your high-level concept, take us through some of the theory, and then we can do the last part, which is the Q&A for the last 20 minutes or so, bearing in mind the time. But thank you once again for joining, ladies and gents. We have 50 people who are now part of the session. And Clement, if I've left anything out, I'm happy for you to get in. But I'm happy for us to kick off really where you can just take us through the theory and conceptual issues and stuff. And then at the right time, we can then do a Q&A when you are done. And just before you proceed, there will be instances where sometimes I would get in. Please do pardon me. I just sometimes just want us to direct the conversation depending on some of these questions that come. Over to you, leadership.
Uh, Thank you very much to me, and I have no problem with you coming in as and when you feel like, any other person who wants to engage us to do so. As a law lecturer, that is one thing that I've grown to be accustomed to. That students interfere as and when they want to, so we can actually have, and it makes the discussion lively because it shows that people are listening. Because if you can say something that will trigger somebody to respond, it seems to me that that is the right way of moving. So please do feel free to get in as and when you feel like it.
Cool.
And you know what? I want to start with a disclaimer, as I usually do, that this is not a legal advice, nor is it a session where I provide expert opinion on everything that I'm talking about. If there's anyone who wants like dedicated expert reflection on their specific problem, I mean, if they do contact me, then and I assist them as an attorney. So I'll be more than happy to certainly do that.
Thanks.
But yes, I would also like to emphasize that yes, indeed, we want to apologize for what happened last week. It was just unfortunate. Hopefully, this week we are going to have a seamless and flawless transmission. But I might have challenges because I'm working from home today, so my internet might might be a little bit weak. But we'll see as to whether it will be able to carry us. One hopes that it will. Today we are generally dealing with aspects of divorce or divorce law, as it were. In that everything that when we started, we started with parental rights and responsibilities, and you find that when those do not go well, then people ask for those things, and sometimes people ask for those parental responsibilities and rights in the context of separation. And today, generally, we are dealing with separation. We are dealing with separation either for people who are married or those people who are living together, but they are not necessarily married, and what are the legal consequences. And of course, I'll just try to give an overview of what we are dealing with, and of course, we'll zoom in into specific questions as and when they do arise.
Sure.
First and foremost, the divorce is simply a dissolution of marriage. That is just the legal definition of it. It's just dissolution of marriage. Divorce is a legal concept wherein you go to court, and it is the court that really declares you to be a divorced person. It changes your status. Only a court of law, a regional court or a high court, has competence to actually declare your marriage to be dissolved. And dissolution of marriage is different from annulment of marriage. When you annul a marriage, it's just like you are treating it as if it had never occurred. It's not like you are divorcing. You're just saying this thing is invalid. It should not have been the case. It should not have came forth. So it's a different story. So what we are dealing with today is just divorce. Perhaps maybe we can start with the grounds of divorce. We basically have 3 grounds of divorce. But I'm not going to mention them because all of them, because the two others are really they're not really significant that much because they're not really that prevalent in practice. The main ground for divorce is irretrievable breakdown of the marriage, and you will see when you receive the papers, you will find that the attorneys are saying the marriage has irretrievably broken down, and there is no prospect to restore that marriage. Hence, you want to go to divorce. And in South Africa, we have a no-fault system. While parties might have high emotions and they are blaming each other for this or that, it's immaterial. If you want to divorce, you will divorce. You don't have to, somebody doesn't have to do anything like really material to you for you to divorce. You can wake up one day and say, I want to divorce, and you will divorce. But the thing is, you need to give the factors that support your divorce. One of them can be, I don't like this person anymore, or I don't love this person anymore, or there is no meaningful communication between us. It can be a ridiculous fact, but if it is important to you and you don't want to carry on with the divorce, then you can divorce. That this marriage has irretrievably broken down because we are not communicating effectively, or the person has committed adultery, or perhaps this person lied to me, the children that are part of the marriage are not my children. So there may be so many issues that might lead you to want to divorce. Whatever the factor is, you can include it there as a a supporting factor to demonstrate the irretrievable nature of the marriage. So, and in South Africa, we are using a no-fault system. In other words, you don't need anyone to be at fault for divorce to carry out. So you don't have to go to court and plead fault, conduct that is unsavory on another person. It's immaterial. Yeah. But in most instances, you find that there is fault. Somebody might have done something, and you are going to court and say, "No, I can no longer stand this person. I just want out." Yeah. So those are the issues that will come in. I mean, I've seen things like somebody is denying the other person their conjugal rights, like they're no longer having sex. You know, it's like, I'm married, you no longer have sex with me. Like, what's the point? I want
to we here, yeah.
So those are the issues that will come. So when you are preparing to divorce, it is important that you realize that while divorce is the most important thing in that process, but for the purposes of your life, there are other issues that are extremely important, like children, like property.
Yes.
So it is important that whoever you instruct to assist you with your divorce really knows their stuff in relation to the rights of children and the obligations that parents have in relation to those children. Last week's debate comes into play.
Yes.
Or the property, your rights to property. A lot of people miss out because at the time when divorce is instituted, you go to someone who's lazy to find out how much asset does the other, assuming that you are married into property, that is, how much in terms of the value of the assets, how much are we playing around with, what does this person have, and all those things. So if those things are not taken into account appropriately, you might lose out. So you need to have somebody who really understands their family law, but their divorce law in particular, and some of the nitty-gritties that come alive during divorce proceedings, because they are emotive by their very nature, and some people hide assets and all those things. So it's important that you find somebody who will be able to unearth all those things that are hidden. At times during divorce, what might be important, and which something that can necessarily be the largest asset in the marriage, might be one of the parties' pension fund benefits. If the person is working at a government institution or whatever company and is part of or is contributing towards saving towards his or her retirement, you'll find that during that particular process, it is important to know how many retirement funds does the other person actually contribute to. There is this myth that says you can only claim from one. No, you can claim from all of them. So because they are part of the patrimonial benefits of the marriage as and when they accrue to the joint estate. So it's important that you understand those things so that you are not found wanting in relation to the laws that you might suffer when things are not done properly. So the issues of property, they are key, and it is important that you pay particular attention to know how much assets or the value of the asset that the other person brought into the marriage, so that you can actually calculate. Because remember, like we said in the first session, that you are the owner of those assets in an undivided share.
True.
In other words, you don't own 30%, you don't own 50% if you are married to property. You own 100%. But you are just an owner, it's not divided, but you are part there too. So it is important to make sure that all the assets are taken part of. But this does not mean that it follows when people are married in community of property that they will be able to share in all circumstances. There is something that is called forfeiture of patrimonial benefits. So it is a common law remedy which has been codified in Section 9 of the Divorce Act, which can be relied on to stop the other person who might not have contributed to bringing a particular asset in the marriage from benefiting from that asset. Like, for instance, let's say I marry someone, and during our marriage we want to divorce, and while we were married, I purchased a house, for instance. And when I purchased the house, this person did not contribute a cent in this house. And at the time when we are, and this person does something that forces me to divorce them. And at the time of divorce, to force a situation wherein this person will not benefit from that house. And the remedy that is used, is forfeiture of patrimonial benefits. Basically, Section 9 of the Divorce Act, it gives you 3 grounds upon which forfeiture can be established. And these grounds are not cumulative. In other words, they do not all need to see them. You can rely on only one of them or all of them. If you have only one of them, you can rely on them. The first requirement that is important in relation to forfeiture, it is the fact that you look at substantial misconduct.
Yes.
You look at substantial misconduct. Even though we said that divorce is no fault, but if somebody's conduct is such that it brings you to decide immediately to say, look, I'm done with the divorce. I cannot continue in this relationship with this person. You can rely on that to say this person should forfeit their share on my property or on my pension benefits or whatever, on the basis of substantial misconduct. There's a lot of literature on what substantial misconduct entails, but it needs to be something more severe that would have driven you to want to divorce. The second one is circumstances that led to the breakdown of the marriage. Sometimes something happens now, and you don't immediately take the decision to divorce. And you say, no, let's reconcile, everything is fine, sham. That is the circumstance number 1. Then you find that after some time, something happens as well, and you don't divorce. Up until one day you say, no, I've been forgiving this person. This person has been doing a lot of things. So now we are going to look at those circumstances that led to the breakdown of the marriage. This is one of the factors that can actually be taken into account. The second one is the duration of time. The third one, it is the duration of time. We look at how long were you married for? Usually, marriages that took longer, you find that it's difficult to find to successfully claim forfeiture of benefits. But if people were married after 2 months, 3 months, a year, you can actually say, look, actually this thing was not a marriage at all because we were just testing this thing out. So there's no enough one. But you need to plead for it carefully. So it's important you go to somebody who really knows how to deal with this particular remedy. There have been concerns in relation, because it is a common law remedy. We inherited this remedy from Roman Dutch system. So there are debates as to whether this remedy is constitutional. And at times it raises also gender issues, because people have argued that reliance on this particular remedy, it prejudices especially women who normally, or in most instances, they find themselves in financially weaker positions. That, this remedy has been designed as a financial punishment for women. So there are those debates around this remedy. As whether it will be able to survive the constitutional muster, we don't know. But what we know is it is definitely in operation. You can rely on it, and you can actually plead one of those, or all of them, or some of them, those factors, and you can rely on them, and certainly you can get your forfeiture. But it's not easy to claim it. You need to have somebody who really knows it and knows the jurisprudence behind it, so they can help you to claim for it. One remedy which is not also that prevalent nowadays, but it was back in the days, it was the redistribution order. In terms of Section 7, Subsection 3 of the Divorce Act. But that particular remedy, it was time bound. It was only for certain marriages who were entered into before 1984. All the marriages that were entered into before that period, you can actually rely on the redistribution. In other words, redistribution is when you find that people are married out of community of property and they divorce, and you find that the wife does not, or the financially weaker spouse does not have enough assets, the court can redistribute assets. They can say, no, because this person will be left in a financially weaker position, we are going to take this TV and give it to her. We are going to take that and give it to her. But nowadays, for marriages that were entered into after 1984, the redistribution order is not applicable. So in practice, it's not necessarily that important. But it's one of the remedies that can actually be taken into account when one is dealing with a divorce. I don't know, do you want to come into somewhere?
And yeah, I mean, one of the things, and I think if I look at the insights, we particularly dealing with people who been married post 1994, 84 rather, as you pointed out. So these are young people and stuff. And I think I like the forfeiture of assets discussion and what it means. Substantial misconduct, circumstances that led down to the breakdown of marriage, and the duration of the said marriages as the three things that may well be considered. Someone is asking, what is the YouTube channel called? You'll find it. It's my handle. You can search it on YouTube, and then you'll be able to subscribe and find what we discussed last week, amongst other things. But Clement, what I wanted to ask you on this is, are you able to plead in the alternative, substantial misconduct, and or as lawyers would ordinarily do, or you just have to choose one, or you can have three in the event that one is not successful in forfeiture?
There is no science to it.
Yeah.
You are dictated by the facts. So you cannot, it will be self-defeating to claim it in the alternative. Because the facts will guide you. The facts will show you what is applicable. In most instances, people usually rely on substantial misconduct or the circumstances that led to the breakdown of the marriage. Because when you look at them, both of them are fault-orientated. And there is no, I mean, if you want to be a legal purist, you can say, but this is the same thing. These are fault. I mean, how do you distinguish between the two? They are really the same thing. So the real distinction really is between the duration of the marriage and these two. So in most cases, you can claim all of them or one of them, but there's no benefit really to doing in the alternative. Like if I fail on this one, I will rely on this one. Then if you can, both of them are competent, then rely on all of them. But you only need to prove one. If you prove one, then you move. And the reason for the redistribution order being applied only to marriages that entered into in 1984, it is because of the Matrimonial Property Act. Because the Matrimonial Property Act gives people a choice to choose to marry in community of property, out of community of property, and out of community of property with the application of the accrual system. So that particular system was not there for people who were married before 1984. This act came in the mid-80s. So as and when it was promulgated, the legislature's intention was, now you have this particular choice that people can choose from. So once they choose, they will be bound to what they choose. So there's no need for us to deal with this redistribution order. If you choose to marry out of community of property, that means you know what you're doing and we move forward. But we really do understand that there is this financial unequal bargaining relationship that is there in marriages. And sometimes the person with a stronger financial muscle usually dictates the terms. But the law, when it looks to these issues, it says like parties are at the same footing, but we know that they are not. And whatever they contract into, they ought to be bound by it.
100%. Thanks a lot, Clement. We will obviously just now move to other aspects, but there are two things that came as part of the questions on forfeiture, and I think maybe because we're still on it, we can just dispense with it quickly. It's been asked, with the forfeiture of patrimonial benefits, can a party forfeit a portion maybe that was agreed in the antenuptial contract or in an accrual claim? I don't know if you would need more information, but that's one question.
Actually, when you look at the thing is, both the Divorce Act and the Matrimonial Property Act, and funny enough, both of them in Section 9 of the respective, they deal with forfeiture. They deal with forfeiture. So yes, forfeiture can be partial, or it can be in full. But it won't be something that will be included in the antenuptial contract, because it is a legal remedy that you cannot plead it before you actually, because if you're going to include it in the antenuptial contract, that means you are anticipating that you're going to divorce. So you are preparing yourself even before you get married, that now I'm going to divorce, and when we divorce, forfeiture will be applicable. But because forfeiture it is as a result of the conduct of the parties during the marriage. So it's not something that you can foresee that, okay, in future this will be the case. It is something that can be claimed only after the event has actually taken place.
100%. Thanks for that, Clement.
Sorry to me.
Yeah.
And I see that somebody's asking, what about customary marriages? It
Yes.
applies equally in customary marriages, customary marriages as it does in civil marriages.
Yeah. All right. There's a question on, can a spouse claim from the beginning of the retirement policy or only the value accumulated during the period of the marriage, for example? So on these type of things. So I start working, I get in, when you are
dealing with the pension with pension benefits.
Yeah.
What normally happens is a pension portfolio is not part of the holder's estate.
Yes.
In other words, at the time when this person is still contributing and building it up, he or she does not have a right to it. So the fact that this person does not have a right to it, it means their spouses do not have a right to it as well.
That's right.
So now, at the time of the divorce becomes a trigger event to release that benefit. And once you divorce and it triggers the release thereof, as a spouse, depending on the marital regime that you are married into, you will develop a right because it will automatically fall within that person's estate, the member's estate, and by implication into the joint estate. So the value that will be due to the member had the member resigned on the date of divorce. In other words, if there was no divorce and the member resigned and he was entitled to 5 rand at the time, in other words, if the person would resign now and he was going to receive 5 rand, that value will be taken as a pension interest. And you are going to claim from that value as the non-member spouse.
Great stuff. No, I think it makes perfect sense. I'm mindful also of the time, Clement, and if we could just then get on to, so dealt with forfeiture and do you want to do high-level spousal maintenance?
Let me wrap these ones. Spousal maintenance is one of the when people get married, they have a duty of common law duty of support towards each other. They need to support each other by virtue of marriage, irrespective of their marital regime. The duty 100%. Of support is applicable. Whether you are married out of committal property, in committal property, you have a duty to ensure that you support each other. So at the time of divorce, any spouse can claim maintenance from the other. But there is a criteria that is followed by the courts when you look at Section 7, Section 2 of the Divorce Act, which assists on
Clement?
At the time when you are claiming divorce, the court will look at in the lifestyle of the two parties. It will look at their respective earnings. It will look at whether they need their needs in terms of and the ability to pay as well. So those are some of the criteria that is going to be used. In other words, in most instances, the spouse that earns less or nothing will be able to claim maintenance from the other. But what we have seen now is the courts are more in line because there are two types of maintenance. You have spousal maintenance that is permanent maintenance, and you have spousal maintenance that is rehabilitative in nature. In other words, it's temporary. It just meant to assist you to be able to rehabilitate yourself financially for a certain period, maybe for a year, 2 years, 3 years, or 10 years. So it will depend in the circumstances as to which one should be applicable. And the court nowadays, South Africa, are more in line to order rehabilitative maintenance as opposed to permanent maintenance. But this is not a birthright for wives or women. Even men can actually claim spousal maintenance. You know, in my practice, I've never seen a man who's claiming it. But I always ask my clients, are you going to claim for this thing? Because you can claim for it. Because surely this woman makes more money than you. You can actually claim. You know, but there's a lot of ego that happens there. So
it goes with that.
This is not a birthright for women. Both women and men are able to claim spousal maintenance.
Spousal maintenance. Thanks a lot, Clement, for that. Yep. let's
yes, let me move on to these ones. Sometimes you find that people are not married. They live together and they live for years and years and years, and the marriage goes sour. And when the relationship goes sour, and when the relationship goes sour, the question is sometimes you have contributed towards the property that you are living in. You have supported each other in terms of buying cars. You have contributed so much in each other's lives. And now when you leave, there's nothing that bears your name. And the person whose everything bears their name, they'll say, no, this is my house, this is my car, move out and go. We are not married. We are not attached to each other. No, you are. Basically, in South Africa,
can you just repeat that comment? Sorry.
What I'm saying is, when people are living together and they are not married to each other, they will say, no, we are not attached to each other, but you are. You are attached to each other. And this is how. Generally in South Africa, there is no law that regulates cohabitation. Cohabitation is not codified in South Africa. There's no law that deals with cohabitation. You cannot go and say, look, I have these rights because I'm cohabiting with somebody and all those things. What you need to bear in mind is the courts have been so, and there's this issue of when you are cohabiting with somebody, there's a common law marriage between the two of you. In South Africa, there's no such thing. We don't have common law marriage. Those things, they happen in Canada or Australia and all those things. And the fact that you have been married for 6 months, 6 years, I mean, you have been living together or cohabiting for 6 months and whatever, it doesn't mean that you are married or you derive. Exactly. You don't derive marriage-related rights by staying with somebody for a long time. You don't.
Great stuff. Thank you.
And what happens is the court try to find.
I'm saying that actually has been a myth that's been spread that 6 months, a year later, you are basically married and stuff. So I think it's a very important point to make. And if anything from this IG session, you can rewind after and then take that clip and put it out there and encourage people to watch that aspect, because I think it's something that's been misconstrued and not factual. Sorry to interrupt.
No. It's fine. Now, when one looks at cohabitation, when you're cohabiting, it is important that when you feel like now you are ready to stress each other, to live together, to be in the same place and stuff, it's better to write a contract, to conclude a contract, draft a contract that will define the terms of your relationship. This thing is usually called a cohabitation agreement, but there's no such thing. But that's what it's called, cohabitation agreement. Whereby you're going to say, look, as far as assets are concerned, we are going to do this. As far as children are concerned, we are going to do this. Sit down, go to an attorney, try to draft a cohabitation agreement. So that when that particular relationship goes south, you know that you can rely on the personal right that the agreement itself creates. And you can actually sue on the basis of that agreement. Let's assume that you don't have that agreement in place. What the courts have done, they have ensured that they really come to the assistance of women in particular. There is something called universal partnership. So people are residing together, they are helping each other in so many ways. There is this concept of universal partnership that has been created by the courts. It's a common law concept, it's a company law concept actually. It's a company law concept, entrepreneurial law concept, where they say the two people who are in this kind of relationship, they are actually in a partnership. And this partnership is so universal that both of them are deriving benefits from it. So at the time when your relationship goes south, what you can do is you can try to quantify your contribution to this kind of partnership. And when you go to court, you say, in this partnership, I contributed 10% and I want my benefits. I contributed 20%, I want my benefits, or whatever percentage. So it is one of the ways in which you can get something when you are actually in a cohabitation relationship. But most importantly, again, when you look at some of the statutes that we have in South Africa, they define the word spouse broadly. Like, for instance, the Insolvency Act. In some of the provisions, they define a spouse to also include people who are in a cohabitation relationship. When we look at some of the Constitutional Court judgments, when they define the word spouse, they define the spouse broadly to include that. In the pension law segment as well, we are going to deal that with pension law in the last session, and we are going to deal as to how they define spouse. But universal partnership is one of the ways in which you can defend and protect your rights in a cohabitation relationship. Or even if you don't have a universal partnership, you can actually claim a joint venture. If you can demonstrate that there was some form or there was some form of joint venture between the two of you, and you can demonstrate it, which is a company law concept as well, you might get something out of our court. So while our courts have been very creative in trying to extend some sort of protection to these kind of people, or people in these kinds of relationships.
Great stuff.
I think, yeah, I've covered all these things that we plan to do. Oh, division of assets.
Yes.
When you divorce, obviously you don't divorce only to separate. You divorce only to also to separate the assets. So one of the prayers will be division of the assets. In other words, I came with cutlery, I want my cutlery. Or if we don't quantify them in that sense, when things are sold, we know that everything is sold. We decide that we are going to divide them into two, or we make compromises. I'm not going to claim from your pension fund, but I'm going to take the house. So it will depend on the skill of the attorney that you have and their understanding of the game as to how your rights should be put. So it is a myth that when you are married, either come to property or otherwise, that you have this 50% thing. Because I've heard a lot of people running on the base of this 50%. You can get 90%. You can get 100%. It depends on the skill of the attorney that you have. And the more skilled the person that you have, the better your chances in relation to your divorce.
And it's very unfortunate, Clement, I think, in power dynamics on these type of things. And as to your point earlier, with women at times not having a lower advantage, somewhat, I think from a reform perspective, we need to start talking about training and equipping attorneys to be at the level where if Tumi is a millionaire and they're breaking with the wife or divorcing, the wife is not shortchanged, amongst other things, because at most, from a, as I said, equality perspective and a reform perspective, it's women who really go through these type of things. But added to that is obviously the lawyers who, unfortunately, the wife would have found herself with, who really didn't know or sought not to protect her interests. So it's very important to always just shop around and find people who are skilled in this thing and not settle for less in these type of situations.
You are raising an important fact, and I think us as lawyers as well, we are at fault here, because and sometimes the economy plays a role. If you are running a law firm, you get a client, says divorce, you don't know anything about it, you take it up. That's what normally happens. But I don't agree with that. That should not be the case. Like, for instance, to me, you are a labor lawyer person. You know, you are a labor law person. Theoretically, my labor law is sound, but practically it's not. So I will never take out a labor law instruction. From a theoretical basis, I'm sound on it. I know that. But from a practical, there are nuances in practice that I'm not aware of. So I will never do a labor law matter. I will never do a road accident fund matter. But funny enough, family law is one of those areas of law that everyone feels like they can do. And to the disadvantage, most of my clients are post-divorce clients, where things went wrong with their attorneys, and they come and say, let's try to fix this thing. And you want to get your client from the very first day, so that you can really walk with them through the journey and really assist them through this process. But I mean, as attorneys, if we can learn to pass things around, if I get a labor law matter, I know to is there, I pass it on there. If you get a pension law matter, you know I'm there. So things like those. But we don't do that. But sometimes it's understandable. People are trying to, because it's tough out there, people are trying to navigate this law thing. But it is important that when you are going to a lawyer, try to go to somebody who really knows the kind of problem that you are dealing with.
100%. Thanks. I think that hits it on the nail, Clement. I don't know, you have any other maybe theoretical concepts that you want to cover? I'm mindful of the time. Maybe we must just get on to some of the questions that have been raised.
I think one thing that I can wrap up this discussion with is every divorce can be settled.
Yeah.
Every divorce can be settled. What most attorneys do, they become part, they enter the arena because it's very emotive. They become part of the extension of their clients. And when an attorney is an extension of the client, it will be difficult to settle the matter. As attorneys, we need to divorce ourselves from the matters and look at the matters rationally and not help our clients with the irrationality when we look at these matters. So the first point of call is to try to avoid lengthy divorce processes. You need to ensure that you explain the consequences, you explain the law, you explain everything to your client so that you can try by all means to settle the divorce. You know, the divorce should be done in a dignified manner and ensure, especially when children are involved, ensure that you don't break relationships between parents. Try to mend the relationships rather than to break them. And when you do that, it will be a win-win situation. Divorces should not have a winner. They should not have a winner. But unfortunately, ours is very adversarial, and we always have somebody who's happy and another one who's not. But I think all the divorces can, and sometimes I've had a matter which ran for 7 years. After 7 years, parties settled.
Yeah, these things do happen, and it's not in anyone's interest at the end of the day. You know, as you correctly said, I think as attorneys have a duty of care in these instances, and we need to exercise it. Being officers of the court, more importantly, saying, although I represent my client, but it doesn't really help to be running this journey for such a long time in circumstances where it's reasonable or otherwise. And related to that, Clement, you know, it's this question, for example, where you speak about 7 years or so. One person had asked that, you know, I haven't been receiving a response from my husband, who we are now in a divorce process, and he's the one who initiated it, but I can't get a hold of him. The lawyers are not answering the phones, and it's just frustrating. Is there something that can be done in these circumstances so that at least either we can finalize it or get out of it, for example?
No, definitely. There's something that can be done. It depends on the level. One, if the person, I mean, and again, you know, there's this myth that when you are the one instituting, therefore you're going to win. It doesn't work like that. You know, instituting just means that you just started the process. All of us are going to be invited to the table. So when somebody institutes and he goes to the attorneys and they are not responding and stuff, your lawyer can actually set the matter down for hearing. And the matter can be finalized. You don't really have to run around and try to get somebody and all those things. I mean, you can explain to the court that this is the process. And again, to divorce somebody, you don't need their consent. Divorce is not a consensual sort of process. That's why you're going to court. You're just going to say, if one person doesn't want to be in a marriage, that's enough. You don't need two people to want to divorce. So, but sometimes you find that I'm going to answer this question because it raises another question which might not necessarily have been the question that was intended, but I think it's important. Sometimes you're married to someone and that person is nowhere to be found and you want to divorce them. Or sometimes, you know, sometimes when we found our brothers and sisters from other countries and we started marrying our brothers and sisters in South Africa, and after a month they disappear, you don't know where they are. So those kind of marriages,
actually came up.
Those kind of marriages, there's a way in which to divorce. You can divorce by way of either by way of substituted service. You just say, look, we don't know where this person is, but we hear that he might be in Kagiso somewhere. So you just do it by your lawyer will explain to you what substituted service is. Or if somebody is outside the country and you don't know, you know that this person is in England, you can do it by a dictal citation. So it depends on the circumstances. You can divorce somebody even if you don't know where that person is.
Thank you. That's very important. In fact, it's one of the questions that came. One of the questions is, if your ex is a bully and doesn't uphold agreements within the divorce decree, what's the next step? Effectively, can you take them back to court for them to uphold what is contained in the divorce decree, perhaps?
A divorce decree is a divorce order. Once an order has been made, we expect that the order should be carried out. And if the order is not carried out, that is a contempt of court. Of course, you can go back to court to enforce your rights. But if the person is a bully, then a protection order will be needed so that you can be protected from that person. But if there is something that the court said should be done in terms of the divorce order, and that thing has not been carried out, you can go back to court and try to enforce that thing should have, because that is a contempt of court. And contempt of court is a criminal offense, by the way.
People take it you know, and it's quite serious. And you know, it ought to be known that if you are found in contempt, you risk being jailed. It has happened even in labor matters or any other thing, because it's quite serious. You are effectively disrespecting the court and the justice system as well. So how long must one be in a cohabitation partnership for one to be able to claim these benefits when you break up? I think
I mean, there's no science to it. I think it is more about, it's not about the length of time, it's about the contribution. I mean, if you are in a relationship for a week and you have somebody to buy, because you know sometimes love can go through the roof. You get in within two minutes, you are already giving the guy or the woman 50,000. Yeah, go and purchase this thing. If that happened within a week, then there's a substantial contribution. So it depends on the contribution, not necessarily more about the length of time.
Right. Okay. I'm just taking these questions that have come through, you know, anonymously and without compromising people. One of the questions that came is, I earn more income than my husband. Will the court still acquire him or require him to pay maintenance?
I mean, if you earn more than him, he is the one who's going to claim maintenance from you. Yeah.
Great stuff. I think that answers that, Clement.
There's another question. Can a party apply for maintenance after separation in a cohabitation? No. There's no duty of support in cohabitation, so you cannot necessarily claim for maintenance from a maintenance point of view. But of course, if you rely on the issue of joint venture and universal partnership, you might be able to get some financial reward from the relationship. But cohabitation does not give rise to duty of support.
100%. Now, is it possible to cede rights and responsibilities of assets and debts when married in community of property at divorce?
So that you might not get that one?
Is it possible to cede rights and responsibilities of assets and debts when married in community of property when you are divorcing?
To cede them to?
Yeah, it's not clear.
To the other spouse?
Probably to the other spouse, if at all.
Look, perhaps it might not be the issue of cession per se. It will be once you sit down and you negotiate. You can say, look, this is how we want to divorce, and you are drafting a settlement agreement to say, look, you're going to take care of these debts, and perhaps I will not claim from your pension benefit, something like that. Yeah. So in a way, you are kind of like ceding, but it's not cession per se. So in the process of negotiation, it can be a give and take. If somebody will say, look, I don't want you near my pension benefits, then you will say, no, are you going to take care of all these debts? Then if he says yes, then that's fine. He pays the debts, you don't claim the pension benefit. So it can be a give and take. It will depend on the circumstances. 100%. But you can agree to cede your right from a property. Like for instance, if you agree that the person will get 100% property and you both own that property, you will have to cede your right to him so that it can be registered with the deed registry. So cession in that context will be applicable.
Great stuff. Thanks, Clement. I think that's right. Someone is asking, which marriage regime do you recommend? Do you recommend?
None.
Because I'm an attorney.
None.
Yeah. So can we pass on that? So contempt. Clement, if you pick up something.
Yes, there's another one who asked, what are the documents that are needed for for customary marriage. And I think maybe the question, it was in relation to forfeiture. The process of forfeiture in relation to customary marriages, it is the same as that of civil marriages. You just need to rely on those three requirements. If one of those is applicable, or one or more of them, then you will be fine. We are going to have, next week we are doing customary marriages, so we'll unpack the customary marriages thing quite nicely next week.
Great stuff, Clement. Thanks for that aspect. What happens when a husband, for example, pays little for the girls after divorce, and the other party now is unemployed? Can that person, which is the wife or ex-wife, go back to court and ask for more money, for example?
In principle, yes.
Okay. Like that disclaimer.
There is this thing called, sometimes there are people who don't need maintenance at the time of divorce. So if you have a skilled attorney, we will advise you to ask for token maintenance. Token will be like, you're going to plead for 50 cents, for instance. You're going to say, no, I want 50 cent maintenance, just token. At the time when you need maintenance, then you go back to court and say, that 50 cents is not working for me. Let's increase this thing. You know, so in principle, yes, you can go back to court to ask for more.
Great stuff.
But that doesn't mean that it's foregone that you're going to receive it. It's going to be a fine, of course.
Yeah, great stuff. What happens to one's asset when a couple divorce without a prenup? Both parties have children from separate marriages. I think this is just a consequence of a marriage in community of property.
Community of property, default position. You share everything that is available.
Yeah.
But sometimes it can be complicated, because there are people who are like with marriages. Whenever they get into relationships, they get married and they get divorced. So sometimes somebody marries someone and within 2 years they divorce, and the assets of that marriage are not distributed, and they get into marriage with another person. So you find that at the time of divorce with the second one, there is a dilemma as to how you deal with assets. So under those circumstances, the circumstances relating to the lack of division of the past marriage must be taken into account, because if they are not, that former wife or husband will be left out. So he or she needs to fight for their rights as well. In other words, the person who got into the second marriage must have came to the second marriage with 50% of the previous marriage, not the 100%. Because otherwise, the new wife or husband will benefit from the other person's assets. So you need a skilled person to assist you with
this. Someone had pointed out that there are, as a gentleman, well, he's not a gentleman because...
To me, I'm mindful of time. I think
I was about to say,
we need to wrap up this thing, then we can come back.
Let's end this session, save it on IGTV, and then let's take another 5-10 minutes. Hopefully there won't be load shedding like we did. So if you have data and you're able to join us for the next 5 minutes or 10 minutes just to take your questions, we would appreciate it. But ordinarily at 7 on the dot, Instagram just shuts it down. But we will save this. We'll put it on YouTube, IGTV. You find it on Facebook as well. But we will just join in the next 5 minutes. So let's meet here at 19:05 for quick Q&A. We can do that for 10 minutes, and we can wrap up this session appropriately. Thanks for joining in. We really do appreciate your insights. Those who are able to join in, we'll do that for 15 minutes. Those who can't, it will be on IGTV and YouTube. We'll share the links on the various social media networks. Thanks, Clement. See you. Hey guys, welcome back. Thanks for joining. I know in South Africa, data, it's not an easy thing, but we do appreciate you being part of these sessions and your opportunity to learn from us and us learning from you. Hi, Lindiwe, how are you? See you in Tabi. Happy birthday, in Tabi. Thanks for taking time to join these sessions. We appreciate it on your birthday. Again, as I said, we are not going to be long. It's just really to do and take some of your questions relating to divorce law and anything you wanted to ask or what was not clear. Rara, thank you so much for joining. I see now you are a master on Instagram. Just click, guys. No, thanks, Rara. Yeah. I was just welcoming everyone back and really saying once again, thank you for joining. I think it was such a great and very informative session when we just spoke. Right now, what we are going to do is to really just do a Q&A on divorce, on spousal maintenance and cohabitation, and we can keep it to 10 to 15 minutes. The cleaner, I see you. Do not, I repeat, do not take screenshots and Photoshop us on Twitter. I know you are very ungovernable, but nonetheless, you must go tell your followers to actually join this session right now and follow us so that they can learn a few things. One question just came through. Are your assets acquired before and during a marriage safe from divorce if they are in a trust?
It will depend, and that is one of the most important things.
Yeah.
When one look at trusts, the question will be, when was the trust created? Who created the trust? Who are the beneficiaries?
Yeah.
And who are the trustees?
Yeah.
And there are different kinds of trusts. Usually in these kind of divorce matters, you find that discretionary family trusts are created. Now, the court will have to assess whether this trust was created with the sole purpose of hiding assets. In other words, is it a sham? So if it is a sham, the court will pierce the trust veil and will say these assets were hidden here and they are actually in truth part of the joint estate. So, but if now you're married and you create a trust, you want to develop your wealth and all those things, and one day you get married and you continue to have that portfolio in a trust, you stand a better chance of convincing the court that it was not a sham arrangement. But surely, if you are using a trust in that sense, it might be good as well to do an anti-mutual contract, just to clarify certain things. But of course, the assets that are in the trust are not owned by the creator of the trust or even the trustees, are just for the beneficiaries. And sometimes the beneficiaries might not necessarily have been born at the time. So in principle, they are safe, but it will depend on the trust deed as well. Why was this thing created? And what kind of a trust is it? And what is its role in relation to the marriage? So those are some of the things that are going to be taken into account when the court makes its decision.
Yeah. Thanks for that, Clement. As you said, these are things that a court would ordinarily take into account. And we see it, now and then. Wills and trusts are always spoken about, and some people generally had trust. I see you, Mavusan, alter ego, Ratanang trust. Absolutely, you know how these things are. Is there a limit to the payment of spousal maintenance when there are no children involved? We touched on this last week, but maybe, Clement, because last week we had to end abruptly on these issues. Maybe you can just repeat and clarify whether is there a limit on the payment of spousal maintenance when there are no children. Maybe you can even do when there are children and no children, because we spoke about it.
There is a limit generally on maintenance. Yeah. But the limit is dictated by the party's lifestyle, by the party's circumstances, and the general way of dealing with things. Of course, when you claim a particular figure, you must justify to the court that, one, you need it, you need to show need. Secondly, the ability to pay. You need to show that the other person is able to pay. So you don't claim maintenance because of what you believe the other person earns. Claim maintenance on what you need and what will sustain you post the marriage. So there will generally be a limit. It will depend on what you believe you need for whatever purpose. So you will claim a particular amount. The other person will come and say, can I afford that? Am I willing to pay that? And so forth.
Right. Great stuff. Thanks, Clement. That's very helpful. I'm not seeing any other questions. Maybe I might have missed it. But these cohabitation agreements, you know, because I think the notion of set is quite one that is known and it's prevalent.
It started less.
Yeah, you know, it definitely does start at race and stuff. But are you in a cohabitation agreement, for example, obviously say this is per se not a marriage and it's just really more of a cohabitation agreement, and can it be akin to sort of a cohabitation in community of property if I were?
Look, if in your agreement you say things like when we acquire this, we will jointly have shares on it or something like that. If you can look, cohabitation is not community of property, but the manner in which the contract is drafted, it can have the same consequences. It will depend on the terms. If you're going to say, look, if we purchase a house in 3 years' time, we will be joint owners of that house. And if this person retires or he resigns or whatever, then this person's pension benefits, we are going to equally share the. So now you are turning it into marriage community of property. So it will depend on how it is drafted.
Yeah.
But in itself, it's not community of property.
Great stuff. All right. So one question that came, and I'm not just putting up on the screen, but I'll just read it out. If both parties prior to divorce create a trust and then later get divorced, will a court, for example, probably think that is it a sham or otherwise, or parties in that they could create a trust for the benefit of the kids and still get a divorce order?
But the thing is, a trust is a sui generis institution. It's not it's not something that is really regulated. It's not like a pension fund, for instance. It's not like a company, for instance, even though you are dealing with trust principles. So in other words, the question would be, who are the beneficiaries? Are you and your husband or you and your wife creating a trust, and you and your wife or you and your husband are actually beneficiaries? I mean, I'm not that clued up in trust law, but you cannot create a trust and become the trustee of the trust and immediately become the beneficiary of a trust.
Beneficiary of that.
You know,
I
there
think
should be some division of roles. People create trust to benefit from trust. In other words, you become, you elect your wife or whoever as a trustee, even though you are the one who have created it, and you insert your children as beneficiaries. But as a trustee, you derive benefits from it. You manage it. If you have a trust and it has properties, you collect rent, you benefit from it. And of course, I mean, people who have in-depth knowledge in trust law, they can come in and try to clarify some of these things, which I'm not necessarily an expert of anything trust related. I just have a basic level information in relation to them. But I mean, it depends on how it is created and the reason the reason it was created.
Cool. Thanks for that, Clement. Mavusan is asking about girlfriend allowance in cohabitation. What happens when the relationship ends? And I know I'm laughing because sometimes, you know, it becomes a real issue, you know, amongst other things, while funny. But these are some of the realities that we find ourselves in.
No, I did not get the question. You said something about cohabitation?
Yeah. Girlfriend allowance in cohabitation. What happens when that relationship ends?
Look, man, it depends. I mean, I really don't know. I really don't know.
Yeah.
I would think what I will claim there, one, perhaps legitimate expectation. I'm not sure if it is legitimate at all, but I'm not sure if it is governed by law. Or even, you know, I'm not really sure. Can you claim loss of future earnings? I really don't know. I really don't know.
I hear you. It's quite a noble word.
This girlfriend, boyfriend allowance thing, I really don't know. But I think it's a privilege that you lose. And if you lose, and if it was promised to you, and if somebody promised you, like, I'm going to give you this thing for the rest of your life, then that verbal agreement, it won't be much about the content of the agreement. It will be the principle behind it. Like, there's an in-principle agreement that this thing will happen. Perhaps you can rely on that. And I'm just trying to be a lawyer.
No, I hear you.
I really don't know.
I hear you. Here's one question, Clement. Regarding Rule 43, is there a limit with regards to spouses' liability for their partners' legal fees?
You know, it is really important, and I want to. This one thing that I wanted to speak about last week. Rule. Let us not call them rule whatever, because there are different rules depending on which court you are at. We have a similar rule in the magistrate court that deals with. This is basically interim maintenance. When you are dealing with interim maintenance, and most people are not aware of this, interim maintenance, especially when you are married in community of property, you are not asking maintenance from your spouse. For some reason, people believe that you are asking maintenance from your spouse. You are not. You are just saying there is one spouse who has full access to the assets and financial resources of this marriage. And since we are parting ways, I don't have equal access. So the fact that I don't have equal access, there's nothing I can do about it. I need the court to come to my assistance. So in the interim, while we want to clarify our rights in the assets, I want the court to declare that I need this amount in the interim for me to survive. So people think that interim maintenance is, and unfortunately, most of the attorneys, that's how they practice it. That interim maintenance is about the need of the wife. He needs to claim 5,000. Can this person afford that? No. You look at the estate. You look at it and say, look, what have I enjoyed? What can I enjoy going forward? What do I need? What has been taken away from me? And what is reasonable under circumstances? Financially, in cash, what is available? What can I get on a monthly basis? In other words, you are asking that the estate that you are going to fight for maintains you in the interim. And this is clear. I'm not really writing a paper about it now to me, because this is something that needs to be clarified. Even the courts are getting it completely wrong. You find things like, oh, you think this person is rich, he can afford this. No, it's not about him. It's not about her. It's about the joint estate. I'm saying I need something from the joint estate for me to survive. Because this person does not have any restriction to the joint estate. He's enjoying the joint estate because he's the one who's controlling it. I don't have access. What you are saying is I need some access while my rights are being considered. I'm not sure if that is clear.
No, I hear you. And
please, if there are people who have a different view, please bring it up so we can debate it.
More importantly, write a paper that says otherwise, because I think that really contributes to the jurisprudence and the sharing of knowledge. You know, because this is what it is. What is the situation when on divorce a court makes no order with regards to pension interest, and the pension interest is then paid out after a divorce? Is the spouse subsequently entitled?
Can we not answer that and leave it to the last session?
We can do that because we have a specific one.
Let me just say this. If the law in South Africa, the law regarding pension interest in South Africa is a mess. It's an absolute mess. Currently in South Africa, if your divorce decree or order is silent on the issue of pension benefit, there is no pension fund that will release any money. basically. But we'll expand on this. And the issue of retirement annuity as well, we'll deal with it because there are developments now in South Africa relating to this. Retirement annuity is not a pension fund. It's an insurance policy. Retirement annuity fund is a pension fund. There's a difference between the two. Oh, sorry, man. I meant to say living annuity and retirement annuity fund. Living annuity is an insurance policy. Retirement annuity fund is a retirement fund. It's a pension fund. It's the same as provident funds and all those things. But we'll deal with that in the last session.
Yeah. All right. Are they allowed to ask anything related to law of succession? What about it?
No.
Because that may well be issues of children and maintenance and the like. But
in succession, you have interstate succession, which has its own act. You have testate succession. Now, if somebody dies testate, they have a will. They have declared what needs to happen. If they die interstate, then they don't have a will. The Interstate Succession Act will determine as to how. Normally, it will be the spouse who gets something. If there is no spouse, children, or the spouse and the child share. So there are all these complications in relation to succession law.
Great stuff. Clement, I think you know we've done our part. I'm mindful of the time and the questions, but more importantly, the fact that we've had over 50 people join this Q&A session. What it says for us is people are finding these sessions very helpful and informative, and the only way for us and our duty really is to impart this type of knowledge. But that doesn't mean that you'll take this as legal advice, because situations and facts are quite specific. And if you find yourself in that, it is then important that you consult an attorney. Clement has made the point so many times about how intricate these issues are, and you may miss out, or you may find yourself really shortchanged, and therefore it becomes important to consult properly and make sure that your rights and interests are protected. But what we do not take for granted is the fact that you decided to spend at least an hour and 15 minutes with us when you came through with your questions, when you listened, and really we do appreciate that. We've taken note of a possible session on trust and stuff like that. There are a host of people who specialize in those type of things, and we will see how we picture it. Remember, do follow, subscribe. The handles are the same. Clement is on Facebook as well, and on Twitter. You need to get a profile picture, Chief, on Twitter so that people can see who you are. You need to move with the times.
No,
this is what it is. But we do appreciate it. The links will be up this evening for the YouTube session, including this Q&A, and we'll also share it on Facebook and Twitter. And we're happy that you also share it with your friends, colleagues who may well find these information sessions useful, and they couldn't join, amongst other things. Do have yourselves a lovely evening, and keep safe. COVID is still with us. Do what's best. You need to drink responsibly and be responsible as well. Clement, final parting shots. Clems?
Yeah, you are cutting up to me, man. Can you hear me?
Yeah, we can. We can hear you. I'm saying final parting shots from your end. Clement, are you still there? ESCOM and data and everything else has started. I think Clement would convey and reiterate my well wishes and thank yous to each and every one of you who joined the session. Thank you. Next week we have another session, but in fact I'll tell you now. Next week it's week 3. We're going to be focusing on customary marriages and burial disputes. As you would know, this is one of those big things that keep coming. I mean, there's various case law on this. There's issues related to how is it handled. So tell a friend, we're doing customary marriages and burial disputes. There we'll be looking at living requirements, the role of lobola, and the likes. So do tune in. We'll put up the poster. We'll keep sharing. You can find the entire schedule on my IG profile. I've put it there, and we've set out what we are dealing with, and you can share that. Thank you, everyone. We really do appreciate your time. Have a lovely evening.